first-headed monster, disability, probate, incapacity, guardianships, conservatorships. Oh no. Hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's video in question is, how does the law define when an elderly person can no longer live at home alone? Folks, pull up your chair, get your pen out and your notebook, because I will be teaching you what the answer is. Folks, think of activities of daily living. They refer to this in the elder law industry as ADLs. ADLs, or activities of daily living. What is activities of daily living? Well, they're the things we all need to do when we get out of bed in the morning. So think about it from a practical standpoint. What do you or maybe your senior loved one need to do or should be able to do independently and safely on their own? Practical things to get out of bed in the morning. Number one, ambulating or transferring out of bed and maybe walking to the restroom or the bathroom. So transferring is one activity of daily living they ought to be able to do independently and safely. Number two, toileting. Number three, bathing. Number four, dressing. And number five would be eating. Activities of daily living. They are the bedrock 5 standard activities of daily living. There also are some additional activities of daily living, such as managing medications and taking their medications independently and properly. Also, maybe preparing meals, maybe talking on the telephone, things of that nature. So looking at all these, the totality of the circumstances is really, really important, all with the common denominator of safety, making sure that your elderly loved one is able to do these things safely by themselves. Other things to watch out for is the elderly loved one. Are they incapacitated or are they completely incapacitated? So the things to look out for would be things, safety factors, where they may be a significant fall risk, maybe other matters where they might be considered a vulnerable person. There might be some abuse going on, some financial exploitation, either with family members or strangers taking advantage of that elderly person financially. That's when you want to get involved and protect them. Those situations may not rise to the level of them not being able to live at home any longer, but they should all be looked at in the totality of circumstances. Other things like hygiene, are they taking care of their hygiene? Are they bathing regularly and so forth? Are they opening their mail? Are they paying their bills? All those things should be taken a look at as well. So first and foremost, my recommendation, look at the ADLs, activities of daily living, that we just reviewed. Look at, are they safe in their home and so forth, and are they able to cook in their home? Things of that nature should be looked at as well. So long and short of it, a person may be declining in health. It's really, really important for the family to keep their finger on the pulse, observe and monitor the activities of daily living, ensure that their loved one is safe. If it gets to the point where you think your loved one is no longer safe, if they're hoarding and they're not using the toilet and their home life appears to be dangerous, then you may need to step in legally and petition the probate court for a legal office called guardianship. In order to obtain guardianship, you will need to support that petition to the probate court with a medical certificate or a clinical team report signed off by your loved one or elderly person's medical providers or doctors, okay? And the judge will need to review that medical certificate or clinical team report to ascertain if their incapacity rises to the level of them no longer being able to make their own medical decisions for themselves. Also, strong recommendation, typically recommend the folks, when you're petitioning for that guardianship, that fiduciary office of guardianship to manage a loved one's medical affairs, that's what guardianship office is, it would be wise and prudent also to strongly consider also petitioning for conservatorship, because that will also give you legal authority to manage their financial affairs. Oftentimes, because the two of them go hand in hand, you will have to get access to their finances to pay their bills, their medical bills, maybe new housing, maybe assisted living facility, maybe independent living with home health aides coming in, maybe a skilled nursing facility, or if their level of incapacity is so great, maybe a memory care unit, which is oftentimes private pay. So the guardianship that you petition the probate court for under the laws will only typically give you legal authority in most states to manage their medical affairs, make their medical decisions, things of that nature, but not manage their financial affairs. So you'll need that legal conservatorship as well. You'll have to wear two legal hats in this regard. So that's how the law typically will define when an elderly person should not live or cannot live any longer at home alone by themselves. Usually activities of daily living, safety factors that we talked about that would warrant loved ones or other folks stepping in, petitioning the probate court, guardianship to manage their medical affairs, conservatorship to manage their financial affairs in their best interest. So folks, there you have it. How the law defines when an elderly person can no longer live at home alone. Folks, if you found this video helpful, please scroll down, post a comment, post a question, because a member of our team will get back to you as soon as possible. If you'd like to learn more, strongly recommend pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, because you will learn how to slay the metaphorical four-headed beast. Folks, we'll see you next time at elderlawcare.com.